What's a motion to suppress evidence? A motion to suppress evidence is a pleading filed by a defense attorney asking the judge to kick out certain pieces of evidence, which sounds great, and why wouldn't you want that in any criminal case? You can file a motion to suppress if there is a legal issue with how the evidence was obtained. So for example, if your attorney believes there was a problem with the stop or a problem with the arrest, that might be a reason for a motion to suppress to be filed. Similarly, a motion to suppress can be filed to keep out a statement or a confession if the defense lawyer believes that the statement was obtained illegally. So let's break down those three scenarios in a little bit more detail. In order to stop a person in Texas, an officer generally has to have reasonable suspicion that something illegal happened. That's a very, very low standard. In reviewing the evidence, if your attorney believes that there was not even reasonable suspicion to stop you, then the attorney might file what's called a motion to suppress the stop, asking the judge to consider whether or not that evidence should even come in. That evidence meaning anything that happened after the stop. Similarly, if an officer has not established probable cause for an arrest, or probable cause to draw your blood in a DWI case, or probable cause for a search, then a defense attorney can file a motion to suppress that search or that arrest, and therefore anything that arises out of that search or the arrest. A statement can be kicked out if it was obtained illegally. In Texas, there's an additional requirement that certain statements have to be recorded. There has to be at least an audio recording of a statement obtained by the police, which is different than federal law. But at the very least, if a person is in custody and they're being interrogated by the police, Miranda warnings apply. So if a person was not given Miranda warnings, or we can show that the Miranda warnings that were given were ineffective. So for example, the person doesn't speak English well and they did not understand the rights that they purportedly gave up. Those might be instances where we file a motion to suppress to keep that statement out. A motion to suppress can be a very useful tool in a defense attorney's arsenal. So if you believe there may have been some issues with your stop, with your arrest, or any statement that you've given, then you definitely need to talk to your attorney about that so appropriate pleadings can be filed. We made this video in response to a question we received on this channel. If you have a question about criminal law in Texas or federal criminal law, drop a comment below. We'll address it in a future video.